We are Commissioners of Arts.
Tanlo Solicitors, first floor, 4 Manor Terrace, Friars Road, Coventry, CV1 2NU.
Or call us on +44 2477 632 323. Tanlo Solicitors. Immigration, family, civil litigation, and employment law requirements, contact us. We also specialize in business, corporate, and charity advice. We are Commissioners of Arts.
Tanlo Solicitors, first floor, 4 Manor Terrace, Friars Road, Coventry, CV1 2NU.
Or call us on +44 2477 632 323. Tanlo Solicitors.
I'd like to welcome you all to today's program sponsored by Tanlo Solicitors, and my name is Andrew Nyamayaro. We just want again to have an update on the immigration law and immigration topic. And as we wait for some more people to just log in, I'll just put a promotional video for now, just for
all your
seconds.
Immigration, family, civil litigation, and employment law requirements, contact us. We also specialize in business, corporate, and charity advice. We are Commissioners of Arts.
Tanlo Solicitors, first floor, 4 Manor Terrace, Friars Road, Coventry, CV1 2NU.
Or call us on +44 2477 632 323. Tanlo Solicitors. For all your immigration, family, civil.
Okay, today we want to do a rundown of the immigration updates as we normally do if we are not doing any other topics. So the first thing that I want to touch on is the recent case that was done in the courts recently. It is the case of CSM, in which case the applicant or the claimant in that case was a person who came from the Democratic Republic of Congo, and that person was HIV positive from the age of 4 years. That's when he was diagnosed with HIV, being HIV positive, but he was born with the HIV. So he came to the United Kingdom with his parents, and he lived in the United Kingdom, and he committed some crimes, after which he was deported to the Democratic Republic of Congo, where he says that he was tortured and ill-treated by the authorities in Congo. Thereafter, he then found his way back to the United Kingdom and was detained by the Home Office. When he was detained by the Home Office for some days, the Home Office did not give him access or did not give him his medication, and that obviously had some impact on his health, as that affected his count, as the CD count. So the Home Office was taken to court, and the Home Office was found by the court in the judicial review that there was a systematic failure by the Home Office in that they failed to provide the medication of this particular person while he was in detention. So maybe it's a case which maybe he might have to seek compensation of some sort from the Home Office. So where the Home Office fails to provide medication to a person who requires medication for them to live or to survive, the Home Office will be acting in an illegal way, and you might have to bring this to the attention of your solicitors or your lawyers so that they can assist or help you. The other update that I have is that, as you would know, there is some deportation of Zimbabwean nationalities that has taken place, and some more deportations have also been scheduled to take place in the future. Some people are now receiving new removal directions for deportation to take place off my head, I think if it's not the 8th, it's the 12th. But so sometime soon, another chartered flight might leave the United Kingdom for Zimbabwe. I still encourage people, those who are in detention and those who might face detention and who have got deportation order, to prepare for their cases again, so that they may not be deported under the circumstances. I've also had some inquiries from clients who say that they might consider voluntary return because they do not have protection issues. As you know, some people came to the United Kingdom because of protection issues. Some people came to join their spouses or their families. Some people came to study and do whatever things that they came to do here. So depending on each individual circumstances, some might still be afraid to go back to Zimbabwe. Some may not have any reason to be afraid to go back to Zimbabwe and might opt for a voluntary return, which is still there, and it can be arranged by the Home Office at any time if someone deems that it's an option available to them. And for those that have got families and those that have got children in the United Kingdom, it's also important to make further submissions or new applications or judicial reviews as may be necessary. There has been quite some time now since the first deportations took place on the 21st. So I think most people would have started preparing themselves, and injunctions on a short-term basis might not be difficult to get because people have had some time to prepare for themselves. I also understand that some groups, some human rights groups and political parties, they also continue to get together to put pressure on the government, to put pressure on the ministers, on the parliament, to get around to the authorities so that these deportations might come to an end. It is quite important for these activities to take place. It might be peaceful demonstrations or processions that might take place, and also engaging with the media, engaging with human rights organizations, and engaging with different people that might be sympathetic to the cause of people that being put into removal, that are being forced to be removed from the United Kingdom. So it is important to either become a member or to subscribe or to sign any petitions that are being circulated by the different people that are helping in this important cause. Another comment that I have is that with regard to COVID-19 visa, if you would remember, in March 2020 or sometime thereafter in April, the Home Office produced an immigration COVID-19 guidance in which they introduced what is called an exceptional assurance leave. It's not necessarily a visa in itself, but it gave an opportunity to people that were in the United Kingdom but could not travel back because they were kept in the United Kingdom because of the international lockdowns or the restrictions that were there at the time. This was extended almost on a monthly basis, and the extension is still there. As we are now aware, the United Kingdom have lifted all the restrictions. We are no longer in a lockdown, and it's also looking at the situations in other countries. So the exceptional assurance is still there, at least for now, until the 30th of September, and it's now applicable to countries that are on the amber or on the red list. So if you came on a visitor's visa or you came on a student visa or whatever visa that you had a limited leave to remain in the United Kingdom and you cannot go because of COVID, you can still make an application for the exceptional assurance using the email that they've already put on their website, the email that has been put on the website by the Home Office. So one question that I get in relation to the exceptional assurance is that can someone then get an a job and start working in the United Kingdom if they've been on an exceptional assurance. And that will then also depend on what your potential employer or employer is doing. If they can generate a sponsor certificate for yourself and they're happy with that, then they can do that. But some universities have been causing problems and refusing to accept exceptional assurance as a basis for someone to remain in the United Kingdom and therefore get their visa from here, and they want them to go back and come back and go back to their home country and come back. But I think, in my view, that might be a breach of the Home Office guidance, because the whole point is to allow people to stay here on the exceptional assurance and switch or change their visa or extend their visa on the basis or that they are still legally in the country. That's why the exceptional assurance was put by the Home Office. If you've got any questions that you want us to discuss or that you think might be beneficial to any other viewers, you can put them in the chat and I'll be able to respond to your questions as much as I can. If it's individual cases, then I'll encourage you to get in touch with me on the details that are appearing on the screen. You can get us on our office phone number 02477632323, or you can WhatsApp me on 00447421429338, or send an email to info@tanlaw.co.uk. Okay, so I'll be checking in the comments to see if I've got any questions that needs to be responded to. So just post in any questions that you might have, and I'll be able to respond to those questions as much as I can. I just want to remind people again of the Zombrano route. So basically, the Zombrano route is a route that allows people or sole carers of EU or British citizens to remain in the United Kingdom. As you would know, the United Kingdom came out of EU the 31st of December 2020, and there was a grace period until the 30th of June 2021. And some people who made Zambrano applications had their applications rejected or refused by the Home Office. The Home Office citing the Appendix EU, saying that if someone has got another basis of claiming a leave to remain in the United Kingdom, then they can use that one instead of Zambrano. But the court said that that is illegal and unlawful. So people could at the time could also apply or have a review of their decisions. If you were not aware of this, although the 30th of June is come and gone by, because these could be exceptional circumstances, you can still make an application under Zambrano and explain the reasons why you could not meet the deadline. So these applications are still going on. I know some people who are making applications on the basis of being EU nationals or European family members are facing difficulties in getting their appeals or administrative reviews, but it's something that can still do to challenge the Home Office. Okay. I've got a question that has come in. There was a refusal of a visitor visa and it said no right of appeal. How do we go about that? If you made an application for yourself or for a family member or a friend to come to the United Kingdom as a visitor, the right of appeal was removed by the Home Office for quite some years now. The only way you can challenge the Home Office if they refuse a visitor visa is by way of judicial review. So judicial review is got give or take 3 stages that are involved. The first thing that you need to do is to do what is called a pre-action protocol. There is a form or a pro forma that has been done by the Home Office. It's on the gov.uk website, which you can use for your pre-action protocol, or you can just do a normal letter as a pre-action protocol. You challenge the Home Office on the reasons why they refused the visitor's visa. They acted unprocedurally, unfairly, they exceeded their powers as a public body, and so forth. And you give them about 14 days to respond to the pre-action protocol letter. Sometimes the Home Office do respond, sometimes they don't respond. But you have to bear in mind that from the date of the Home Office decision, you have 3 months to make an application to the upper tribunal or the High Court for the judicial review. So even if they don't respond, you still have to take note of the deadline. Otherwise, if you go beyond the 3 months, then you cannot make an application for judicial review. So you've gone past the pre-action protocol stage, you can then make an application for permission for judicial review in the High Court or the upper tribunal. In that court, you complete the court form, and then you also give your grounds. It's normally important maybe to instruct counsel to draft the grounds for you. You compile your bundle, paginate your bundle, and you pay the court fee, £155 for administrative review, and then you submit it to the court. At the moment, the court is accepting judicial review applications by email. So if you are doing it by yourself, then they will call you, and you then have to give them payment over the phone. If you are using a company, if they've got a PBA account, they can put the PBA account on the form, or they can still pay over phone or by check. But doing by check will then delay the proceedings. Once you have submitted your application, the court rather will seal your judicial review, and you have got 9 days to serve it on the GDL, the government legal department, who are the lawyers for the government. And then you have to submit a statement of service, the T485, to the court, and then the court will make a decision. The court will initially make a decision based on the paper, so the response from the Home Office, your application. If the response is against you, then if you want, you can seek for oral submissions. You pay another court fee. Off my head, I think it should be £550 for an oral hearing, and it is you have to have a barrister who has got the rights of audience in that court to address the court, and then depending again on the decision, it might come in your favor or in the other person's favor. So basically, there's no right of appeal if your visitor's visa is refused. You have to go by way of a judicial review. It's a tedious and expensive process, and you should have very good grounds to follow that process. Most representatives hesitant to go for judicial review unless if there is very good grounds because of a case that is called Hamid. The courts have been trying to discipline representatives, and if they submit applications, especially agent applications for injunctions and so forth, which the court believes that they've got no basis or breach the rules or procedures, then they can be called by the court to explain themselves, and the court might refer them to their regulatory bodies, which might result in disciplinary proceedings and so forth. So practitioners are very careful when it comes to judicial review. Do children under the age of 18 pay the NHS for the visa application for family visa? Yes, they do pay the NHS. It's called the IHS. The people that are currently exempted from paying the IHS are people that are coming to the United Kingdom under the skilled worker, under the sponsor license, the healthcare sponsor license. Those ones are currently exempt from IHS, but anyone else is liable to pay the insurance health surcharge which comes to about 1,560 for 2.5 years. So they are required to pay the insurance health surcharge. If you are in the United Kingdom and you cannot afford to pay for the fees, and it's on a qualifying application, it could be the limited leave to remain, further leave to remain on family or human rights, but not settlement. You can make an application for a fee waiver. And for a fee waiver, you are saying to the Home Office either you are destitute or paying the money will make you destitute. So you're asking them not to pay for the Home Office fee, and you're asking them not to pay for the insurance health surcharge. If your application for a fee waiver is successful, they'll give you a code which you then have to input on the online application that you are doing, and then your application will then be considered on its own merits, whether or not it's going to be successful. Some people, if you're not in the United Kingdom, can make an application for exceptional funding to the Legal Aid Agency. If you are given exceptional funding, then the Legal Aid Agency will cater for the costs for you, and hopefully, depending on your merits of your case, again, you will be successful as well. Okay. What are the requirements for bringing children or a childminder to the United Kingdom? So this is a gray area. If you are, say, a member of the embassy or a member of the diplomatic community, you might be able to bring someone as a childminder. For everyone else, a nanny or a childminder is quite now difficult to bring someone on that basis, especially that you not be having a sponsor license or to generate a sponsor certificate, and for some people to generate a sponsor certificate as well. It's something that the Home Office has not come out clear, but at the moment, for individuals, I would say in my submission that you cannot it's very difficult for you to be able to bring a nanny or a childminder under that topic, because that topic has since been moved or changed. And I would say you have to look at other options of either getting someone from the United Kingdom who can maybe be able to do that, or use the facilities that are in the United Kingdom. Okay, so those are the questions that I've had so far. I will just check on other platforms if I've got any questions or contributions regarding the immigration cases. Okay, so in terms of other areas of law that we deal with, Tanlaw Solicitors does employment, family law, civil litigation. We also draft wills. We are also commissioners of oath, and we also work with other solicitors in Zimbabwe or another country when it comes to, say, multi-jurisdiction cases. Sometimes people do have properties in the United Kingdom and in Zimbabwe, and they want, for example, a will to be drafted, or there is an administration of an estate to be done, or people want to save papers from Zimbabwe in the United Kingdom and vice versa. Under those circumstances, we can also be able to help. Cases that we are seeing happening in terms of employment is settlement agreements, where employers are now laying off people and giving settlement agreements, and also cases of furlough and things like that. Furlough is going to come to an end, I think, in September as well. So there might be a lot of redundancies that might happen, and Tanlaw will be able to help with that. The last thing that I want to touch on today is the issue of an application for naturalization as a British citizen. If you are in the United Kingdom and you've been on settlement, and depending on your immigration history, you might be able to apply to become a British national as an adult. So if, for example, you came as a spouse, you get your 2.5 years, and then you go through the routes, and then you get to your indefinite. You can then apply it for British nationality. Again, depending on your circumstances, if you have got a United Kingdom degree, you don't need to do the English test. If not, you need to do the B1 English test, and you need to do the Life in the UK test. And then if you have been in the country for the past 9 months out of the 12 months, then you can be able to submit your application. You need 2 referees. One can be professional and one can be a British or a both, and they can make references for yourself. It's now done online. One concern that referees have got these days is that the form is now asking for too much information to become a referee, and some people are hesitant to give their information. So the best way would be to maybe give them the login details. They log in, they put in their information, and then log off. You change your password, and then you do it that way, because it's not the paper form anymore where you would just do a 1-page form for the referees. And there's also an application fee that you pay if you want to become a British national. Where you have been in the UK for more than 10 years and your history has got mixed legal and illegal stay, the Home Office would look at the good character requirement. And if part of the 10 years you were illegal in the country, then they will ask you to wait until it's 10 years of legal stay in the United Kingdom, and then you can apply for naturalization. If not, then the application, if you submit it, the application will be refused, and you tend to lose your money. The Home Office will give a suggestion of a date when you can make a new application, but you would have lost your money in the application that you would have made before the 10 years is transpired. In terms of children becoming British nationals, if a child was born in the United Kingdom and they have spent 10 years in the United Kingdom, then they can become British nationals automatically, but you need to make an application for them to be registered as British nationals. And again, if they followed the same route with their parents, they've got indefinite leave to remain, then they can also naturalize on that basis. Another important point is that where a child is born to a parent who has got indefinite leave to remain, that child is born with British nationality if that child is born in the United Kingdom. If the child is born outside the United Kingdom and both or one of them, the parents have got indefinite leave to remain, then they will not pass on the British nationality to that child who has been born outside the United Kingdom. The situation is different to a child that has been born in, to the first generation child to be born outside the United Kingdom, to someone who has got British nationality. That person will be a British national, and you have to follow the procedures to get their passport. So for today, thank you so much, everyone that has been watching and listening. If you've got any questions, you can contact me using the contact details on the screen. And please, for those who are facing deportation, contact your lawyers, your representatives, or if you cannot afford, there's some legal aid companies or even charity organizations such as BID and other charity organizations that can assist so that you can have your cases resolved or dealt with in a professional way that will be able to help you. Thank you so much, and I will be with you again next week. Thank you.